Poorna Mysoor, Dr. Poorna Mysoor, who I've known for almost 20 years. Poorna did her undergraduate degree in Bangalore, and then you practiced before you came to do an LLM at SOAS in London.
That's right, briefly.
And
just
while she was at SOAS in London in 2000,
that's right.
I was then a lecturer at King's College London, and so somehow, did you take my classes?
That's right, that's true.
And I took Poorna on as a research assistant.
The following year.
She did some research for me. She then went off to practice in Hong Kong for 10 years, and came back to the UK in 2013. She started a PhD at the University of Oxford, and her PhD was on implied licenses, which is what she's going to talk about today. Since she got her PhD, she's now a junior research fellow funded by the Leadership Trust at Oxford, working on property and copyright, which builds on, I think, your
That's right.
PhD. So we're looking forward to hearing it. I've not heard this talk before. Very much looking forward to hearing it. So,
thank you, Lionel. Thank you very much for this opportunity to present my work. I don't know if you remember, Lionel, this was your suggestion that I work on this for my doctorate. So I'm very much looking forward to presenting it to an audience that includes you as well. Can I use this to move from slide to slide, or is it?
So I think you just.
I can just. Okay.
We don't have a clicker, do we?
Okay, that's fine.
The mouse might work.
The mouse is fine. Yeah. So, like Lionel said, this builds on my doctoral work, and this is part of my upcoming monograph, which hopefully will be published next year. Hopefully by the end of next year. And I would very much welcome all the feedback that I can get. The manuscript is still in the works, so I can include all the feedback that I can get from this presentation as well. Okay, so let me first start with laying down just where it is that I have understood implied license to fit, and why it is that it matters, and why we should care. So let me first locate this in the larger scheme of permitted acts. So obviously you have at one end of the spectrum the licenses that are expressly granted by the copyright owner. So this is more like prior consent given by the copyright owner, and you can think of clearance culture that prior consent breeds. And at the other end of the spectrum, we have the statutory limitations and exceptions, which are not voluntary as far as the copyright owner is concerned. It's something that the law itself provides. It's situation specific, addresses certain specific instances and needs of users of the users. And we have seen with the CJU interpretation that it's narrowly construed as well, because we conceptualize it as an exception to a rule, and therefore the exception needs to be narrow. Now, what happens if there is a particular use that a person wants to make of a copyright work, but it's neither covered by an express license from the copyright owner, nor is it covered by any of the statutory limitations or exceptions? So we are talking about, if you were to think of this as a landscape of permitted acts, what falls in between, what falls through the cracks, how are we going to deal with them? Are we just simply going to say that they're all going to amount to an infringement, or are we going to be able to get the support of this doctrine of implied license? So you have express license at one end of the spectrum, you have statutory limitations at the other, and in between this terrain of implied license is what I have tried to look at. Now, what are the advantages of looking at implied licenses? So essentially, the role we want implied license to play is to save acts which otherwise would have become infringement. So it's not, if it is neither covered by limitations nor by an express license, then it kind of extends the permitted acts by providing a license which is implied based on the circumstances. Now, what is the advantage of implied license is that it has a level of flexibility to address a whole diverse set of situations. Now, if you can imagine, the reason why I say this is because it's not as rigid as statutory limitations, nor is it as formal as being approaching the copyright owner for prior grant of a copyright license. The flexibility I'm talking about here is that as and when certain uses are to be considered for not having to amount to an infringement, then implied license might be able to support it and save it from infringement. So it's a kind of more fact-specific, situation-specific, and that's the sort of flexibility that we're trying to see, whether a doctrine of implied license which with the right kind of basis can support an infringement discourse. So it will be, if implied license is to be supported, then it becomes an additional means by which we can achieve copyright balance. So obviously, what we're trying to do here is to see whether it can broaden permitted use. And we said that it is going to be something unlike statutory limitations and exceptions, not addressing only the predetermined set of circumstances, but a whole diverse situations. It's more like an ad hoc response to copyright infringement. So the last point being the malleability of this doctrine. Will it help the evolving technologies? Because the one thing that we have seen that copyright has struggled to respond to is when there is sudden change in technology, there are these demands made of copyright to make this big leap by newer technologies. Has the copyright, the rigid system of copyright, has it been able to respond to it straight away? So if we have something like a flexible doctrine of implied license, possibly we can mold it in such a way that it responds to the evolving technological challenges. So that's the aspiration. What I'm saying here is not that we should replace with implied license doctrine everything that we know so far as the permitted use. So I'm not saying that statutory limitations are illegitimate or anything of that nature. So if everything else stays in its own place, in addition to all of it, can we think of a flexible doctrine that fills the gap? If it can fill the gap in such a way that it can achieve some kind of balance which doesn't exist today, then implied license would become the kind of doctrine which would have been an additional help to achieve this sort of a balance. So I'm really talking about those woolly areas which haven't been addressed by statutory limitations, or it has been too difficult for us to think of a copyright owner extending their prior consent to those sort of uses. So that's the overall context in which I'm talking about implied license and why we should care about them. Now, implied licenses obviously have many challenges. I'm going to kind of keep this landscape as such, just so that we are constantly reminded that we are only talking about this middle ground and we are not challenging the pre-existing permitted uses that are allowed by express licenses and statutory limitations. So I'm only going to be looking at the middle ground right now. So what are the challenges? The first thing is, what is a license? Now, a lot of times we think we intuitively know what a license is. Obviously, we've had an exposure to licenses for so long, for probably as long as modern style exploitative intellectual property has been in existence. Licenses have been one of the ways in which copyright or any other intellectual property has been exploited, and therefore we must have an idea what a license is. Yes and no, because when we try to think of licenses, a lot of times what you read in the books is license is a form of contract. And that is, we can go into the technicalities of why license isn't in itself a contract, but that tends to become an incomplete and a sort of limited understanding of what a license is. So we need a concept of license which can span this entire spectrum that I'm talking about. What I mean by this is that a lot of times we think of license as something that is granted by the copyright owner. So we think license is the same thing as consent. Is it? Is license the same thing as consent? So if you look at, I'll come back to it in a bit, but keep that thought in your mind. Is license something which is only consent-based, or is license something that can also support non-voluntary actions as far as copyright owner is concerned? So if we want implied licenses to spread the whole terrain of this middle ground between these two consensual and non-consensual systems that exist, then we need the license to be a malleable concept as well. So that's what I'm trying to explore, whether we do have doctrinal and possibly even conceptual basis for us to talk about licenses in that sense. What does implied mean generally? So the thing about implied, the idea of implying something isn't new. Obviously, we have implied terms in contract, implied easements. So in private law, we definitely have fairly well-worn doctrine of implied terms or implied easements. But the thing about implied is that because of the nature of implying, it gives the discretion to the judge in bringing in something which hasn't been made very clear from the circumstances expressly. So the judge has the discretion of taking into account things that are in the surrounding circumstances. Maybe it's about the conduct of the property owner, or it may be about the other circumstances. Whatever it is, it ends up giving the judge a lot of discretion to handle the dispute in a particular way. So what the other areas of law have done under those circumstances is to come up with principles to govern the exercise of such discretion. So you can look at implied terms in contract. Big books have been written about implied terms, and cases are still fought, and principles are still being settled as to how do we imply a term into a contract. So judges are constantly reinventing the way they approach how to imply a particular term into a contract. It's the same thing with implied easements as well, although it may not be as heavily litigated as an implied term in a contract. But the point I'm trying to make is that there are the constant search is to arrive at principles of implying in that particular context, be it a term in a contract, be it an easement. Do we have those principles to imply a license? More so, imply a copyright license? Do we have those settled principles? Do we have anything by way of a guidance to take us through how it is that we are supposed to imply a license into a copyright transaction? So that has been the biggest problem, I feel. A lot of times, judges have shied away from including arguments of implied license in their judgments, or going deeper into implied license, because they feel a level of discomfort that possibly we don't have enough in the common law doctrine of implied licenses, where we have the right kind of guidance for us to arrive at the right kind of decision. So my work has been that the objective of my work was to make the process of implying a copyright license methodical and transparent. Transparent because we have sporadic cases of implied licenses. It's not like judges have just shied away all the time and have refused to imply licenses. They have gone ahead to imply copyright licenses, not just in the UK. There are cases in Canada, there are cases in Australia. So judges have done something when they have been asked to step in with implied license. But when you look at the accumulative part of this doctrine, it's difficult to see where the principles lie, how the court has made sure that from one precedent to another, they can follow a particular line of principles, just like how there is in implied terms in a contract. So because a kind of following principles hasn't been visible from the existing doctrine, I thought it might be a good idea to put them all together and see how we can come up with a set of principles, what I call frameworks. I don't want to call them principles. First of all, it sounds too pretentious. Secondly, frameworks will maintain the flexibility. It's just a suggestion. It's just something that you can keep as a framework at the back of your mind before you imply a license. So if you give that flexibility to the judges and say, these are broad frameworks, these are broad categories of facts that you need to take into account when you're implying license, then you can maintain this difficult balance in law where you have guidance and flexibility both being taken care of. So that was the kind of tiptoeing that I had to do when I went through looking for a framework for implying copyright licenses. Okay, now how do we go about creating this methodology? What are all the different steps that we need to go through? Now, the one thing, I don't know if you will agree with me, but generally when a problem like this is presented to lawyers, the first thing that our tendency is to classify things, come up with categories and give those categories some kind of rationale for their existence and see what kind of characteristics can be discerned from those categorization. So we like putting things in boxes as far as possible to figure out how we can bring order into a particular area of law. I thought it was particularly relevant for implied licenses because if you look at the range of cases that have come about in implied licenses, the cases that the courts have already decided, they all seem to fit somewhere. They're all there sporadically, just coming up with a flash of light, and then suddenly it's gone. We just don't know how that particular doctrine was taken into account in the next case. There are some cross-references between cases, but really there isn't a line of authority that you can follow as being the guiding principle. So the one thing we can do is we can categorize these cases based on certain rationale and then see how the cases have been decided on a sort of similar basis. So how do we categorize this a whole body of implied license cases? So first line of logic, first line of rationale that I tried to look at was, what is this copyright license in the first place? What is the nature of transaction that underlies a copyright license? So how does the CDPA understand copyright licenses in the first place? So we have obviously consensually granted copyright licenses. So we have we have the provisions of infringement, very obvious ones, where without the license of the copyright owner, whatever is done is going to amount to an infringement. So if the copyright owner consensually says, of course you can go ahead to do this, it doesn't amount to an infringement, so we have that idea of consensual copyright license already in the CDPA. And of course, we have Section 90 as well, which recognizes copyright licenses. So it legitimizes the consent aspect of copyright licenses. But is that all? Is that the only way in which licenses have been understood in the CDPA? If you look at the licensing schemes, copyright licensing, which is a very big chapter, chapter 7, which talks about collective licensing and licensing schemes and certain really sweeping powers granted to copyright tribunal, whereby the tribunal can assess the reasonableness of the terms of copyright licenses. So to that extent, to the extent that the copyright tribunal can change, can alter the terms, can change the copyright fee that is charged by the copyright owner, you can say that there is an element of non-consensual aspect to copyright licenses that are mentioned in the CDPA. So at one end of the spectrum, you have voluntarily granted copyright licenses, but it looks like the CDPA also calls something a license which is not entirely consensually granted. So this makes you think that maybe there is more to license than consent. Maybe consent is not equal to license. Maybe consent is part of license but not the whole picture of license. Maybe license is just something which we need to further explore what it means and what it can be as far as our usefulness of this doctrine is concerned. So possibly it's voluntary and non-voluntary, but then if we were to ask the question, what constitutes a license? In the sense, the reason why I'm asking this question is when you say, if you remember from your land law lessons, when you say what is an easement, especially when it comes to implying an easement, you're first asking question, what is an easement in the first place? What constitutes an easement? Shall we go and see whether the facts and circumstances indicate that these constituents exist before we can say we can imply an easement? So what I'm saying is you need to have a dominant tenement, a servient tenement, and it has to accommodate the land and things of that nature. So private law has come up with this particular methodology whereby when something is being implied, then you go into the question of what constitutes it had it been an expressly granted transaction. And then, having looked at what it would have had if it had been an express transaction, then you go into implied and say, are these categories still in existence in this scenario so that we can imply the same kind of transaction? So if we could do this for easements, could we do this for licenses as well? Do we know, with that level of detail, what constitutes a license? Can we break down licenses into its constituent elements so that those elements can be identified in a particular case when we don't have express terms granting such license? I used Hofeld. I don't want to scare you about Hofeld. I'm not going to go further into detail about Hofeldian analysis, but I found Hofeldian analysis probably one of the most helpful as far as license is concerned. I can take questions on why I found Hofeld useful, but I will park that question aside. It suffices for us to know here that it is possible for us to break down licenses into its further constituents so that we can identify those constituents when we have a situation of implying a license as opposed to an express license. Another reason why the concept of license has to be ring-fenced is also because if we were to say that it's just enough for us to say license is permission, like how they say in land law. In land law, very often, when you pick up a textbook, it says a license is a mere permission. It's a personal permission. If that was enough, if permission as a definition for license was enough, then statutory limitations will also be permissions. They will also become licenses. So what is different for licenses which is not like statutory limitations? So that sort of conceptualization of license is necessary because we're looking at the middle ground, aren't we? We're not talking about statutory limitations. We're talking about something else, which is a permissive act, which is an act which will result in a permission, but which will not be like a statutory limitation. In conceptualizing a license for its own sake, as opposed to any other permissive act, it was very helpful for me to look at Hofeld. And eventually, I was able to come up with a conceptualization of license, which was not only helpful for me to define a license in the middle ground between express and implied licenses, but also it was helpful for me to move the concept of license from consensual all the way to non-consensual. So it's a malleable concept which can move from one end of the spectrum to the other. In addition to this, what helped me was also being able to make this distinction between bare licenses and contractual licenses. This is something I think is unique to common law. I'm not so sure about continental law, especially German law. I think in German law there is more a concept of voluntary non-fit injuria. When equivalent of bare licenses where you don't have any consideration, you just give something to someone.
Well, we would generally distinguish between acts which effectively establish a consent between the parties.
Yeah.
And then implementing these acts, which again is a further legal act, so distinguishing between, say, a license and the underpinning contract would always exist.
Right.
Yeah. That would not only exist for IP law, that would exist for any kind of in-rem property, be it like movables or immovables.
Right. So here again, the reason why this distinction was important for me was because some of the textbooks, even English law textbooks, regard licenses as contracts, licenses themselves as contracts. So it's difficult for us to think of a license itself as a contract if it is a bare license we're talking about. Bare license is a concept which is probably easier to understand in the context of land and then bringing it over to intangible. So in land, things like, you invite your friend over for dinner. So the fact that the person, the invitee, the guest can cross over into your premises, which the person wouldn't otherwise have been entitled to do in law. The person would have had a duty to keep off your land, but because you have given the license to enter your land, it's an implied license, which is a bare license. There is no consideration that flows. It's just one-sided. Why don't you come onto my land for ABC purposes? So that is a very done thing in property, and hopefully I'll be able to give you examples of how bare licenses work in copyright. It was surprising for me to see how many cases there are in the UK, which you can see the copyright owner just handing a poem or handing the lyrics of a song without any consideration. It's a friend. You want to sing in a band? Here you go. I've written this poem. Why don't you sing in a band? Without asking for any consideration whatsoever. So that handing doesn't amount to a gift. It amounts to a license, which the court then went on to conceptualize as a bare license. So that distinction between a bare license and contractual license is essential also because what Henning said, in contractual licenses, there are two things you're looking at. You're looking at the contractual aspect of it, you're looking at the license aspect of it. So there is a breakdown of analysis between what contract can take care of and what license can take care of. So that dual analysis doesn't necessarily exist in bare licenses. So if you're really going deeper into establishing methodology for different types of licenses, then this distinction becomes very, very important. So moving on, the next level of classification that I wanted to look at was bases for implying copyright licenses. Now, why bases? Is because licenses just don't come around like that. They don't just materialize. There's got to be someone who exercises that power. I mean, you can even look at something like a driving license. You don't just get a driving license. You need to do something, and there is a particular authority which supervises what you do, puts down laws and regulations as to what it is that you need to do for you to then gain a driving license. So there is a power exercised by somebody which results in you initially being prohibited from driving on the road, then by complying with certain conditions, being given a license to go on to drive on the roads. So that's the kind of, conceptually looking at it, this is what I wanted to look at. What can be different sources of power that exist in being able to grant this particular license? Now, if we want to look at how the other areas of law have dealt with this, obviously we have contract law, where a similar classification has been brought about. I mean, not everybody agrees that this classification is valid, but I've taken this into account because it's actually very, very logical the way this classification has happened. So essentially how contract law classifies this, I'm sure you all have studied in your contract law class, which is there is one end of the spectrum where you have implied in fact kind of cases where you are trying to recreate what it is that the parties would have provided for in the contract had they expressed this as their intention. expressly in the agreement itself. So it's what we can say as a term that's implied, which is unexpressed joint intention of the parties. So that's what implied in fact tries to capture. So it looks at overall circumstances that surrounds the two parties, the way they have conducted themselves, the way they have spoken to each other, what words have been exchanged, what is the surrounding setting. All of those are taken into account as facts, giving rise to this particular term, which can then be implied into the contract. So that there are special. There is a line of cases which have come up with tests for determining what kind of term can be implied. So business efficacy is one of those, and we have obviousness test as well. And more recently, not so recent now, Lord Hoffman's decision, which brings out a holistic test. So that there are all sorts of ways in which you can come up with something which was not written in a contract but still is read into the contract based on your assumed intention of the parties. How you assume that intention is what this particular methodology tells you to do. Implied by law is very, very controversial in contract law, especially because it creates inroads into freedom of contract. So essentially what you're trying to say is, because there is a particular overarching public policy reason, a court is allowed to read into your contract something that was not agreed between the parties, and the court doesn't have to care whether you consented to it, whether you had intention to include this term or not, but because there is an overriding public policy reason, the court nevertheless is going to read this into your contract. So this is it's not as big a kind of case law that there are probably about 5 or 6 cases which are really landmark cases that are big enough for us to say that there is a category like this. And there are some people who refuse to recognize it as a separate category, but then if you look at the methodology that's followed for cases of that type, as opposed to cases of implied in fact type, you can clearly see there is a distinction. So it is possible in common law for courts to intervene in a contract, especially when it's a contract that looks like it's between parties who didn't have equal bargaining power. So it may be cases where employer and employee, where employee isn't necessarily able to know everything about all the information about how the consent to enter into the employment has been arrived at. So because the employer knows more than the employee does, you read into an employment contract certain terms that kind of brings the balance between employer and employee. So reading those terms into a contract of a particular type, like employment contract, is something that's really a done thing in contract law, regardless of the intention of the parties. Now, in between, there is something in the middle which was very interesting for me to look at in contract law, especially in maritime law, where certain customary practices, certain practices which have been consistently followed in a particular trade or a business or market, those practices, if they have been consistently followed for a long period of time, and if they're so notoriously followed, everybody who enters into transaction in that particular business knows that these customs, these practices exist. They exist also in areas like insurance, for example. If you are entering into certain insurance contracts, or if you're entering into certain shipping contracts, or even if you're entering into some of these publishing contracts, some of these practices are so widely held in these industries that sometimes, even if you don't mention it in the contract, they are read as part of the contract. So they are implied by custom kind of cases. Again, it's not a very big category, but the category exists quite distinctly in maritime law, much more so than many other industries. So it's an interesting thing for us to look at as an inspiration for our purposes in implying copyright licenses as well. Now, can we find these categories in our copyright law as well? Similar categories. Now, I think it would be quite intuitive for us to say consent-based copyright licenses obviously do exist, because copyright is a property right, and as a property owner, copyright owner should be able to do whatever he or she wishes. one of the ways in which the rights can be exploited is by granting a license by way of exercising consent. This is a very controversial area. The state intervention to achieve public policy goal. Now, I would like to first introduce this idea in the area of compulsory licenses. I know that compulsory licenses in copyright are almost a kind of joke. They exist, but they've never been exercised. I believe Section 66 in particular, where you have lending rights, which the Secretary of State is granted very broad powers to grant a compulsory license, has never been exercised. But there are other provisions as well for compulsory and statutory licenses, where the underlying objective is to achieve a public policy goal. Whether the copyright owner consents or not is completely irrelevant. To some extent, they may be relevant to some extent in the sense that if a particular collecting society granted a license, but the licensee regarded the license fee as being unreasonable, they take that license to the Copyright Tribunal and said, can we have this license fee revised? The Copyright Tribunal says, yes, this is unreasonable, and therefore I'm going to revise the rate of license fee. Then, to the extent that the copyright owner didn't agree for the revised fee, you have the state intervening in freedom of contract between the parties by exercising this public policy goal of making contracts reasonable, that you have a different basis for implying, different basis for that particular copyright license to come into existence. So I would look at compulsory licenses as policy-based express licenses to the extent that the considerations that need to go into granting of the copyright licenses are explicitly provided in the statute. I believe CDPA has express provisions. I don't have the provisions exactly, but it says how the Copyright Tribunal should exercise its discretion. So it shouldn't discriminate between parties. It should take into account, if it is a reprographic license, it has to take into account these considerations. So there are very detailed provisions which guide the Copyright Tribunal in granting these policy-based licenses. I call them policy-based because they're not consent-based. They're not necessarily consent-based. They may have originated as consent-based licenses, but because of the intervention of Copyright Tribunal, which is authorized by the statute itself, the license that ends up becoming a more reasonable license is something which is a non-consensual license, which is fairly well recognized within the copyright laws as well. So as far as the bases for copyright licenses to exist, we have found these two. Consent, obviously we have that basis for licenses to come into existence, but we also have policy as the basis for copyright licenses to come into existence. But we also have this middle ground where there are many, many industries within the creative industries where customs, where practices have become customary, so much so that people behave in a way that they think that this was somehow agreed upon between the parties. So apparently media and entertainment business has a lot of these as well. They're not necessarily always written into the licenses, but it's something which the parties know when they're entering into these entertainment contracts. It happens, I think it's also something we experience ourselves too when we send an article when we submit an article for a journal. What the journal does with it, because we don't have a license entered into it expressly at that stage still, if the editor of the journal goes on to make copies or send it to others, all of those are licenses that can be implied based on a customary practice within the publishing industry. So the very fact, it can be consent-based as well, because the very fact that I sent it to an editor means that I've impliedly consented for it to be sent off to review. But in addition to that, it's possible that we can think of it as a customary practice within the publishing industry that the editor of a journal is able to make copies and send it to the reviewers and keep a copy, possibly, even if the article is rejected, keep a copy, possibly. I don't know if such a custom exists, but these are all things that we can think of as being in existence in different industries that concern copyright works. Now, what happens after we made these two levels of classification? So first level of classification was bare licenses and contractual licenses, and second level of classification was consent, custom, and state intervention. Now, I went further in trying to figure out how we can further help the courts in trying to give them a framework individually in different categories of licenses. So what I mean by this is, if there is a bare license which is consent-based, then there should be a consent-based implied bare license. So this becomes a separate category which we can look at closely and see how cases in this category have been decided, and to see whether we can provide a broad framework useful for the courts to steer the case law in the direction going forward. So if it is contract-based consent-based license, then it becomes consent-based contractual license. It's another type of category where you have this dual method of contract stage of analysis to see whether a term has to be implied, and then license stage of analysis where if the term has to be implied, is that term to be a license? What are the considerations that need to go in for it to become an implied license, which is a contractual license? So even the custom prevalent, generally when it comes to custom-based implied licenses, they can be bare license or contractual licenses. It doesn't really matter because custom is the most important aspect to be analyzed. So if you just put them all together in one category, it's not going to hurt. It will still give you a good sense of where we're going with this law. So custom-based implied licenses become another category. And of course, contract-based contractual licenses, which are policy-oriented, then go on to become another category of policy-based implied contractual licenses. And finally, bare licenses, this being the most controversial, bare licenses which are policy-based. So this essentially is my table of contents. Each one of these is a different chapter that I've explored in my thesis. So I can just give you what I have done. Let me go to the next slide to give you an example of what I've done. Okay, so as far as it's consent-based, whether it's contractual or a bare license, essentially the ingredients that we're trying to look at in a license is something that can show you whether the copyright owner has exercised the kind of conduct that requires consenting, and what it is that the copyright owner knows, so that commensurate with the level of knowledge of the copyright owner, you can say the license extends. This is the whole idea of informed consent, yes? You don't consent to something just out of thin air. You know what the consequences are going to be, hopefully you do. If you don't, then from the surrounding circumstances, you're imputed the knowledge of what's happening around you for the people around you to discern that if under these circumstances you engaged in this particular act, then it means that you have licensed me this extent of being able to use the copyright work. So let me give you an example. So there is this Fisher and Brooker is a very, very famous case of House of Lords where Gary Fisher sat through the recording of a particular song, and before recording, he sat through this jamming session whereby he came up with this 8-bar music. Is this case familiar to you? Am I giving too much detail? I know Lionel knows very well, yeah. So Gary Fisher created 8-bar of music while in the jamming session. And then he went into the recording studio and played it for the song, which became the prelude, interlude, and the ending of the song as well. if I had the opportunity to play it, you would know exactly what I'm talking about. It's an extremely famous song. That tune in particular was very well known as well. So he sat through the recording, allowed them to take those 8 bars into their song, go out and record it how many ever times, create a sound recording out of it, market it, play it in other concerts as well. He waited for 38 years before coming back to them, before going to the court to say, I had my copyright on those 8 bars. So you should have shared, I'm the joint author of this song together with you, all of you. So you should have shared your copyright with me. How the case was resolved is another thing. We can discuss that later. But what I'm trying to say is this is a consent-based bare license where he just gave it away. He just gave the 8 bars away without actually entering into a contract that would recognize the consideration flowing from the other members of the band to him in the form of payment of a royalty or payment of one-off fee, whatever it is. So this, when you try to analyze where is the conduct and what is the knowledge based on which you can say his implied license would have extended up to a particular point, the conduct would be that he sat through this recording session. He knew that he was being recorded. He knew what the record was for. He knew that the sound recording that was created was going to be marketed in whatever manner. He probably didn't know the details, but he knew that it was being recorded for commercial purposes. And knowing what he did, he still sat through and allowed himself to be recorded. So the conduct of being recorded would be the conduct that we can say implies that he has given a license. And the knowledge that he does, the knowledge that he does have, gives an idea of how far the copyright work could have been used in different settings. So the court held that this was an implied license for the number of years that he didn't question the use of his work. But going forward, his license has been revoked. So if the band wants to exploit the song any further, they have to recognize him as a joint author, and I believe he was given 40% share in the royalties going forward. So they had to kind of make sure that they sent him those royalties for all the exploitation that happened after the case was decided. So that's the kind of guidance I'm trying to put forward here. If you can think of how, let's say, even other areas of law like contract law, why is it that in contract law we have offer, acceptance, intention to create legal relations, blah, 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 all coming together as constituents of a contract? That's because we look at the conduct, especially in common law, we look at the conduct as objectively identifying certain conclusions for the people who are trying to enter into contract with you. So if you have behaved in a particular way, no matter what's going on in your mind, your behavior will have to be objectively assessed based on what others are coming to conclusion of your conduct. So applying the same sort of conceptual methodology, that if your actions mean something to the rest of the world, then the same sort of action and consequence sort of methodology can be applied in case of license as well. Your conduct represents something, the level of your knowledge represents something, and we put that together as a framework that will guide implying a license, which is a consent-based license. So this same methodology can apply so far as consent is the driving factor, whether it's a bare license or a contractual license. The only difference being what is the level of knowledge. In bare licenses, the level of knowledge is how far it's going to be used. You probably know that you don't you're not going to expect anything back. There is no consideration. But in contractual license, the knowledge will be the knowledge of the bargain. So you will have to somehow be able to prove that this is how much I knew of what the contract I was entering into was, and this is how much I thought my work was going to be used. So in this sort of cases, consent-based contractual licenses, you have a whole range of architects' cases. You may have come across some of them. There is a Blair and Osborne, neither of them politicians, both of them actually in the construction business. One Blair was the architect and Osborne was the developer. So the question was, once the architect designs something and gives it to, even sells it, of course, gets his fee paid for the architectural plans, how far is the developer able to use the drawings? Is the developer himself to use the drawings, or can the developer sell the land and give the benefit of the drawings to the person who purchased the land, and the person who purchased the land then goes on to build based on the same plans? Can implied license extend to a person with whom the architect never entered into a contract in the first place? So is this something that goes through the first person with whom he entered into a contract, where there was always an understanding that whoever you sell this to, because this drawing is something you submit to the council and get planning permission, and the planning permission kind of sits on the land, anyone else who wants to use the drawings will have to, it's good for them to have a benefit of the architectural plans. So there's a beautiful line of cases. It talks about what the bargain is. If the bargain is it's only for the drawings that have been given, and the consideration amount is not necessarily reflective of further exploitation of the drawings, then the implied license doesn't extend to further exploitation. If it is a nominal fee that was given, so in Blair and Osborne, the thing was that the fee that was given to the architect was a nominal fee. He was just given £80, and that was done. And he drew the drawings, and then the court held that because it was a nominal fee, his drawings couldn't extend to benefit someone who hadn't even entered into a contract with him. But if the consideration amount had represented something which was much bigger, then the architect would have had an idea that this plan would have been used for something beyond what was envisaged by the person who was commissioning him in the first place. There are now, some of these points are all remote, because Royal Institute of Architects has come up with these very detailed provisions which will be read into all contracts of architectural design in any event. So there is not that much room for implying these terms anymore, but these cases are very illuminative in showing you how a methodology for implying a contractual license can be arrived at. I'll be very quick with this. Like I said, there are custom-based implied licenses, and those are the criteria that I've drawn from some of these maritime law cases. Certainty, notoriety, reasonableness, not against the law. No custom will be given effect to if it is against the law. So it has to be subservient to the law. And of course, there are lots of other writings that do talk about how in a particular industry, possibly one actor is able to control the way the practices are done. So for example, in film industry, film producers will probably maintain some kind of control over what practices happen. So if that practice becomes the custom, then it might be to the disadvantage of weaker players in the industry. So how do you maintain the balance between different players in an industry? So that reads into reasonableness, but it has to be looked at in industries with heavy inequality, how customs do come into existence and how customs can be maintained without causing unreasonable hardship to certain players in the market. So contract principles of implying by law are the ones that help me figure out what can be the framework for policy-based implied contractual licenses. This is really simply what the court does in these cases is that the court will come up with a particular class of contracts to which this policy-based term will apply. So, for example, the court will come up with all leases should have this particular term, especially the leases where the landlord is the council and the tenants are individuals. Then obviously there is an inequality in the way they can bargain. So the landlord under these circumstances must take responsibilities like keeping the upkeep of common areas and things like that. So this is Liverpool City Council against Irvine, a very, very important landmark case, which is almost like a paradigm case for implied by policy contractual terms. So that methodology is very helpful for us in policy-based implied contractual licenses as well. I don't have very many examples of implying a contract-based policy-based term into a contract, but I could roughly say all those cases that concerned repair. So when you have a sale transaction where you purchase a product which has copyright included in it, together with your purchase, you are given an implied license to be able to repair the product. And in repairing the product, if you had to reproduce some of the spare parts, then that sort of an implied license is read into your sale transaction. Whether that still exists is a very big question. But there have been case law, Solar Thompson being one of the most important. British Leyland, again, another example. But I won't go into too much detail into that. There are nuances that are quite different between the two cases. But these are the kind of cases that I'm talking about. So together with a contract, will you imply a term which is not necessarily agreed between the parties, not even consented to between the parties, but as a matter of policy, the law says that you should read this term into all contracts. You being able to repair your product that you purchase is something that you have as of right as a personal property owner. So those are very interesting to be explored within the contract-based, the policy-based implied contractual licenses. The last one is policy-based bare licenses. This is by far the most difficult one for me to justify why I think there is this category that's in existence, because no court will tell you that they are implying a bare license as of policy. There are two things here. Bare license means that there is no contractual consideration that goes back to the copyright owner. So not only are you depriving the copyright owner of being able to exploit that aspect of his copyright work, you're actually saying to him, we're not going to give anything to you back for the exploitation, but we are going to make use of your your copyright work for certain uses because policy demands that we make use of your copyright work for these purposes. I'll quickly give you an example. There is this case called Lion Laboratories, does Lionel know Lion Laboratories? Yeah. So Lion Laboratories was a case where it was a kind of whistleblower sort of a case where the laboratories was, it manufactured intoximeters. And there were internal correspondence that said that these intoximeters were fallible. They were not graded properly, they were not being manufactured properly, but that was being en masse sold to DVLA, and there were many, many people prosecuted based on these wrongly graded intoximeters. So there were certain employees of Lion Laboratories who resigned from their job. They took these internal correspondence and gave it to the press, saying, that this DVLA is purchasing intoximeters that are fallible, criminal prosecutions being held based on this, so that something needs to be done about this. So Lion Laboratories filed for injunction saying, we have copyright in these internal correspondence, and you cannot publish this newspaper shouldn't publish this, because we claim copyright over it. And the court held that there was also the issue of confidentiality here, and the court kind of read the confidentiality defense in the public policy defense and confidentiality also into copyright. So it was one of those cases where how the public interest defense in confidentiality could have been transported from confidential information sort of cases into copyright cases, how it made that journey, how the doctrinal gap was bridged wasn't very clear from the case itself. But the court just came up with this decision by saying, we have the inherent powers to make sure that we we see that in a particular case, justice is achieved. Whatever is fair, reasonable, and just, we are allowed to do. So if this means that we should stop copyright enforcement in this particular case, then we are going to go ahead to do this. But why does this become basis for an implied license? That's again a conceptual gap I need to fill. If there is more time, I will raise this. I can address this during my question and answer. How am I doing on time?
You should draw to a close and then
okay.
Some questions.
Yeah. 2 points about compatibility with EU law. With the consent-based, I'm not sure if you have had a chance to look at Soulier. Soulier was decided 2018, I think. It talks about, it's a very interesting case on out-of-commerce works and a particular law that was passed in France where it had said that if the collecting society didn't hear from the copyright owner within a span of, I don't know, maybe it was a month, then they could go ahead to license these out-of-commerce works for digital exploitation to any person who comes forward for such exploitation. So it was based on this idea of implied consent. If you couldn't be bothered to come and tell us that you were the copyright owner, then we are going to go ahead to exploit it. So that was the underlying logic behind the law in France, and that was challenged before the CJEU. Well, it was challenged before French courts, and then it was referred to the CJEU. And the CJEU said, you do need prior consent in all cases under InfoSoc directive, prior consent of the copyright owner for whatever you want to do with the work, which comes into the Restricted Act zone. You have to get prior consent, but that prior consent doesn't necessarily have to be in express terms. It can be based on implication as well. So CJU says that in so many words, that implied consent is all right. But so long as you have clear criteria to show you that this consent could have been implied under these circumstances, it's okay for you to depend on an implied consent as well. They still held the law, the French law, to be non-compatible with the InfoSoc directive, but that's a different issue. But the fact is that, in principle, under the InfoSoc directive, it's not only express licenses which are expected. So far as consent-based licenses are concerned, there is also a possibility that you can have implied terms going into such consent, and this is recognized by the CJEU as well. As far as policy-based licenses are concerned, these are most difficult to justify because we have Recital 32, which says the limitations and exceptions are exhaustive. So you can't just authorize the court to come up with a new policy and give rise to a new policy and just tell the copyright owner, we're not going to enforce your copyright based on these policy reasons. There's a reason why we have the exhaustive list of limitations and exceptions. There is a reason why the lawmakers didn't want to have this flexible doctrine where you wouldn't know as a copyright owner when the court will suddenly come up with some policy reason and refuse to enforce your copyright. So I do believe there are very, very deep compatibility issues, at least as far as policy-based WEAR licenses are concerned. But I'm trying to put forward this argument that if you have a WEAR license that's granted based on fundamental rights, let's say, because there is this overriding need for right of information, right of freedom of information being effectuated by way of granting this license, then it would be possible, I think, even under the InfoSoc directive, for us to justify that the court should be allowed to enforce a fundamental right and thereby also permitting the implication of a policy-based WEAR license. It's arguable, but it's a category that's actually very, very interesting. I would have gone through some of these application of implied licenses to specific cases like Swenson or GS Media, how implied license could have helped in explaining or giving probably a more reasonable, logical explanation to these cases, especially the communication to the public sort of cases. I would have given those examples, but that's okay. I mean, I think from what I've said so far, it's possible that you can make those conclusions that this doctrine will probably be useful in newer technologies like that. So that's something to be explored for the future as well. But this serves as a basis on which we can say that implied license isn't something that's an ad hoc doctrine that the court comes up with as and when it feels maybe we should dabble in this. But it is something that can be given a conceptual and doctrinal basis, and it can be given a certainty of the law, and kind of the whole methodology can be made transparent in such a way that the courts feel much more comfortable adopting it and talking about it and expanding on it for future cases, rather than just hiding behind it and saying, we don't want this discretion, we just don't want to think about implied licenses. So I think my work is only just start of a conversation, and I do hope that there is more traction in this area and more number of cases coming up from not just the common law courts, but also some of the continental jurisdictions as well. So that concludes it. Thank you very much.